Grandparents are highly valued members of most families and play an enormously loving role in the lives of most children. But for many children whose parents have separated, their relationships with relatives, especially grandparents, can be highly problematic. Today we're exploring a relatively recent development in family law, grandparents' rights.
Brought to you by AdviceScene.com. Free legal answers from verified lawyers.
Parental conflict can extend to create bad feelings between the adults on both sides of the family. What does the law have to say about parents' rights to decide which relatives their children associate with? How does family law deal with grandparents seeking access to their grandchildren? And what options do grandparents have? Our guests today are well qualified to discuss these issues. First, I'm pleased to welcome Manny Witzman, who's a family law lawyer. And also joining us is Daphne Jennings, a former member of Parliament and current president of the Canadian Grandparents' Rights Association. Manny, Daphne, thank you both very much for being here with us on Family Matters.
Thank you.
I want to ask you both, why do these problems happen? What is it in the dynamic between parents who've broken up and their own parents that often causes children to be cut off from a grandparent?
Well, there are many reasons why a grandparent could be cut off. Not all grandparent cases involve parents fighting amongst each other. Sometimes it's the own parent that is upset for one reason or another with their parent and has cut off contact completely unrelated to the marriage breakdown or the breakdown of a relationship. There can be many reasons for that. It could be an issue where a parent has lost trust in their own parent. There have been issues of abductions, of child abuse, of child sexual abuse, and all of these can be some of the many reasons why a grandparent could be cut off from contact with their child.
Daphne, you've been involved in advocating for grandparents since 1993. Can you tell us what you see? What's your perception about the kinds of situations in families that creates conflict?
Well, basically, first of all, let me just say that 80% of divorces are fine. Parents allow for their children, the family remains intact, grandparents are involved continually. And
but is
happening.
It mostly divorces where this problem arises?
It is, and the divorce that it happens, I'd say about 20% in Canada, where it's very emotional, it's understandable, adversarial, yes, that's our system, and the parents feel very strongly. And the grandparents are often off at the side without people realizing that they can give the support necessary to let the children know the divorce is not their fault. They're not to blame, and that's the strength of the grandparents, but it's not always recognized.
But what would make a parent so angry with either their own parent or an in-law, an ex-in-law, that they would seek their revenge by not letting them have any contact with their grandchildren?
Well, now you're talking about the custodial parent.
Well, yes, because generally speaking, the parent who has the control over the child is the one that the child lives with, wouldn't you think?
Absolutely, and it's the custodial parent in a small proportion of the cases, and that is causing the problems. And the custodial parent can get back and can get revenge and can do all these things.
But what are they angry about? Because I'll tell you, the impression I get, and I've been 16 years in the family court bench, I've seen hundreds of grandparent access cases. The impression I get is that the grandparents took sides during the marital dispute, and the parent against whom the grandparents took sides is not forgiving.
To be honest with you, I have never seen that.
Really?
I have talked all across Canada. I've been in living rooms from the Maritimes straight across Canada, and I have never seen that. The one thing about grandparents' rights, and we call it grandchildren's rights, because that's who we're trying to help, is that we at no time mention the parents. When the children are with us, we never speak about the parents. I might say, if my granddaughter asked, can I do such and such, Grandma, I would say, well, what does Mommy say about that?
And I should point out that you have 7 grandchildren.
Yes, I
so
do.
You have some experience in this area. And so you make a point as a grandparent of never trying to undermine or interfere with the parental authority.
That is the case with grandparents' rights. That was the first thing I was told. Daphne, we never say anything about the parents. When we have the children, just be thankful we've got them and spend our time with them and let them go back. And always encourage them. Yes, if they say, I miss mommy, of course you miss mommy, you love mommy. Or if they miss daddy and he's the custodial parent.
But I don't think it shouldn't surprise you to know that Manny and I, seeing these conflicts in a litigation context, do hear the complaint a lot that grandparents are, and I don't know if it's true, it's an accusation where the conflict occurs, that there has been interference or perceived interference or bad-mouthing. Do you see that in your practice?
I do. There's many accusations. In custody battles and access battles in general, anything involving children, there's going to be accusations once it gets to the courtroom. But it seems to be heightened when grandparents are involved. Oftentimes the accusations come from both sides. The parents have negative things to say about the grandparents' conduct, and the grandparents frequently have negative things to say about the parents' conduct. And it's really the court's job to get to the bottom of who is telling the truth, and do the parents have what's called a good reason to deny contact with the grandparents.
Well, what are you finding in terms of the way the law treats parental rights, not grandparents, parents' rights to decide who your children can associate with?
There's really two philosophies that come from that question. One is a philosophy based on parental autonomy, which is that parents in general, if they're fit, if they're competent, have a right to decide who their children get to see. And sometimes those decisions are good, and sometimes those decisions are not the best decisions. But if they fall within a range of reasonable decisions, then the courts shouldn't interfere. That's one philosophy.
All right, hold that thought. We're going to get to the second philosophy right after this break. Please stay tuned. Welcome back to Family Matters and our discussion of grandparents' rights with lawyer Manny Witzman and grandparent activist Daphne Jennings. Before the break, Manny, you were telling us about the first philosophy, which is that parents should be entitled to make decisions as they see fit in their children's best interests. What's the second philosophy?
The second philosophy, Judge, is more grandparent-centered. It involves the idea that contact between a grandparent and a grandchild is a relationship that's, in the normal course of the events, worthy of preserving. And
so we start from a presumption that it is a good thing for children and grandparents to have a positive relationship.
In the normal course of events, sometimes situations could arise where that's not the case. But in the usual course, yes. And the parents would, in that case, need a good reason why they should deny access to the grandparent. And what we see is that the courts do sometimes find that parents have a good reason for denying contact.
Well, given that all decisions that have to do with custody and access are based on the best interest of the child, what do you think, Daphne, about how that phrase, best interest of the child, has been applied in your experience with the families you work with?
With the families across Canada, the best interest of the child does not mean what it was supposed to mean, which was equal access to both parents, equal time. And that if there was someone that had a beef on the side, that was not to deter any process. They still kept the children first. That is not happening. We might as well call it best interest of the custodial parent, because that's what's happened. And when you bring in parental alienation, you see the anger building up. Of course it builds up. How could you not be angry when you see things happening? You send cards to children, they don't come back. You send Christmas gifts, they don't get them, they don't open them.
But you're talking about equal time between parents. Where do the grandparents fit in that? I mean, I get a lot of parents that say to me, custodial parents, that say to me, why can't the children see the other side of the family when they're with that parent? Why do we need to carve out a special time for the grandparents to visit when the other parent has the children, whatever the schedule is, What's your answer to that?
That is my understanding, that they do in fact see. That is the only time they get to see them unless there's special consideration given. When the father, which is usually the non-custodial parent given our primary care principle, when the father has access, the non-custodial parent, the grandparents do get a chance to see them then, and that's when it's happening. So if there's something other than that happening, I'm not aware of it.
Well, ideally, children should be able to visit with grandparents on both sides of the family, no matter which parent they're with at any time.
Absolutely.
When you think of birthdays, special occasions, family events. Well, tell us then, Manny, in your practice, what circumstances will prompt a court to interfere with a parent's decision to cut off a grandparent and order access to a grandparent?
Sure. Well, one of the most common situations you see is where one or both of the parents of the child has died for one reason or another. And in that case, the courts will be very eager to try to foster a relationship with the grandparents. The theory being that the child has already lost one or both of his parents.
And that's the only connection the child's going to get to that side of the family.
Exactly. Other situations can be more complicated, like when a parent makes decisions that the court considers completely unreasonable, where a parent is vindictive and is angry at their own parent or at their ex-in-law for one reason or another, and the court just can't justify it. The grandparent can't seem to get access any other way. Like you said, the grandparent should be able to get access when the access parent gets access. The idea being, well, why give access to the paternal grandparent when the father has access every second Tuesday? The grandparents can see the child then. If that's working out, then the courts will not want to interfere. It's when the father or the mother will not let the grandparents have access during their own time, and then the grandparents have no choice but to try to go to court if they want to try to maintain a relationship.
So to sum it up, the court's always going to deal with what the court considers to be best for the child. I would think that there would have had to be a strong bond between the child and the grandparent before a court is going to want to preserve that relationship.
That definitely helps. The stronger the bond, the more you see in the cases access being awarded. But it's not a prerequisite for access to be awarded that there be a strong bond. There are cases, though they are rare, where the court decides that it's in the best interest for the grandparent to get to know the child in the first place.
So you've got that factor, and then as you said, the decision by the parent to cut off the grandparent has to have been in bad faith, vindictive, arbitrary, without good reason.
That's right.
So what kind of access, given that occurs, Daphne, what kind of access do you see courts ordering for grandparents? Would you consider it generous, infrequent? What happens?
At the moment, it's very infrequent, and it's definitely not generous. And the grandparents I deal with have no access at all, and they are in distress. And many of them get ill because of the extra stress, which is elder abuse, and they die without seeing those grandchildren.
And you provide support to them, and we will talk more about that. I think it's very important for grandparents who are watching this program to know where they can turn for help. Now, what about the courts actually denying access to a grandparent? It's not every access case that is successful. Do you see some themes there, and what kinds of cases the courts say, no, you're not getting access?
Definitely. The courts frequently find that the parents had a good reason to deny access in the first place. Those reasons can vary from things like that the grandparent abused either the parent or the child. Sometimes it's even the spouse of the parent, of the grandparent, that abused the parent or the child. And even if that spouse is no longer in the picture, just that memory can be enough to give the parent the benefit of the doubt. I don't want my child to be around this person just because of the history that's there.
Well, it's a very, very disturbing dynamic that goes on in a family. We're going to take a break. When we come back, I'm going to ask our guests what advice they have for grandparents who are in distress over lack of contact with their grandchildren. Please stay with us. We're back with our discussion on grandparents' rights, and I'm going to ask Daphne, I was struck by a comment you made before the break. A denial of access to a grandparent is a form of elder abuse. Can you tell us why you say that?
Yes, because grandparents, especially those that have been with their grandchildren often, I mean, it is a family. We're talking about families. We're not dividing people up. And when we speak of that, the grandparents expect, as they get older, to see their grandchildren. And when something like this happens, a divorce, especially one that's so strongly adversarial, with so many bad feelings, and the grandparents are left out, they try, they raise money, they send their life savings trying to help in that some cases, but they're still denied access, and therefore there's stress. And the stress, we know that stress is a killer. And on seniors, stress, with you might have heart problems or whatever, brings death closer, and many of them die without seeing them.
It's a very interesting interpretation. I have never heard it put like that, and it's definitely giving me a pause for thought. I wanted to ask Manny, you know, when you see the cases where grandparents have decided to actually go to court to get some kind of contact with their grandchildren, I get the impression as a judge that this often, the litigation itself, as Daphne said, is so adversarial that it often makes it worse. That the things people write in their pleadings, that they say about each other in court, the conflict got worse. Is it a good idea to sue your own child to see your grandchild?
You really have to take a good hard look at it. I would recommend to any grandparent who's looking to get contact with their child to see a lawyer. It's a very complicated area of the law, and even if you feel you have a good case, a lot of times it's not worth taking to court because of exactly what you said, which is it could make the matter worse. There are a small number of cases where it's necessary and it's reasonable for grandparents to go to court to get contact with a grandchild who's being arbitrarily denied to them. And really what it comes down to is the grandparent's conduct. The grandparent should do everything they can to stay out of litigation between the parents. They shouldn't try to involve themselves or try to destroy their child's relationship with the mother or father of their grandchild just because they don't like that person. That's really going to work against you. But if you've done nothing wrong and you find yourself in a position where now your grandchild that you have a close relationship with and who loves you very much and has been taken away from you for what you consider to be no good reason, then see a lawyer and see if there's a reason why that should stay the way it is.
But
well, Daphne, go ahead, Daphne.
I must say, Manny, that when I was in Ottawa, and I spoke with family law lawyers all the time, and they said that the grandparents in the courtroom often were a soothing atmosphere, and it was much easier to deal with the controversy. That was one thing. And the grandparents, I don't see them, I'm afraid. I'm sorry, Judge, and I'm sorry, Manny, but I have no experience with grandparents who are vicious, who are out to get someone. I'm with grandparents who I say, please have more patience. Keep sending the cards. Sometimes all grandparents can do is sit and wait, and that's the biggest thing we know. We have to just wait.
But you have to be mindful that your only contact is with those grandparents. You haven't heard what the parents of the children are saying about why this conflict exists, which is always difficult when you're only getting one side of it.
Yeah.
You know, Manny and I are in court and we hear both sides of it, and there's always two sides to the story, and you so rightly said it's so adversarial. But I want to ask you something. I can't resist this, Daphne. Forgive me. Mm-hmm. You've got 7 grandchildren. One of your own children is divorced, mm-hmm. and you have a very positive relationship with your grandchildren. Can you tell us, what advice do you have for grandparents whose children are caught up in perhaps a bitter breakup?
Well, the most interesting thing is, of the one son who is divorced, it's his 2 grandchildren that my husband and I have the most contact with, and it's a delightful relationship. And my son said no lawyers, which I thought was very good because he knew what I had seen in Ottawa, and they're what they share. They share 3 days a week. Shared
parenting.
Shared parenting, 3 days a week. He has them, 3 days a week she does.
So this was an amicable divorce?
Yes, it was. Very good. And they're both, they try, if one's got a conference, they'll say, well, I'll take them that weekend. And I just want to add here that the fathers of shared parenting came to see me in Ottawa and said, Mrs. Jennings, would you look at our video? And here are parents, spouses, both custodial, well, not, they were all custodial in this case, and they were married. They all stayed within blocks of each other. The children went to the same school, 1 week with the father and his new family, 1 week with the mother and her new family, and it was amazing. And sometimes a barbecue with everybody. Now, shared parenting, equal parenting, that's what we've got to look at. That's why For the Sake of the Children, which was put out, is so excellent, and it is full of suggestions. In fact, 48 recommendations to change the Divorce Act. The Divorce Act is gender bias. We have to change that.
Well, I'm not sure that I can agree with that, but I have to say that for those parents who were able to work things out, and in your case you said without lawyers, clearly this was an amicable breakup. But you know, and I know, that that's not necessarily the reality for a whole lot of people.
Definitely.
Otherwise, I wouldn't have a job, and neither would Manny, but the world would be a much happier place.
Yes, it would be.
So we're going to take another break, and when we come back, I'm going to ask our guests to give us their final thoughts about what people should do if they're in this situation. Please stay with us. We'll be right back. Welcome back to our remaining moments in our discussion of grandparents' rights. Daphne, you are president of the Canadian Grandparents' Rights Association. Can you tell us briefly what that association does?
Well, I can tell you it started with Nancy Wooldridge, who was the founder and president, because she won a court case giving access to her grandchildren. She got distress calls from all over Canada and the United States. She started an organization, and it's basically to help grandparents and to be there for them. Sometimes we just listen on the phones. That's all we can do. We don't have the legal help for them. And for the last 20 years, Nancy had the phone by her bedside and answered at any time of the day or the night. So it was very important issues. And now we've got justice centers that are recognizing the families as a whole. It is much more helpful.
And the website of the organization?
Is grandchildren'srights@gmail.com.
That's the email address. Manny, any final thoughts to wrap it up?
If you're a grandparent and you find that your grandchild has been denied to you for a reason you don't understand, the most important thing you can do is make sure that your conduct has not been something that you can regret. Stay out of any litigation between the parents. Don't try to poison any kind of relationships. Don't try to get angry and vengeful and see a lawyer. I know lawyers get a bad reputation sometimes, but grandparent access and grandparent custody is a very complicated issue, and I've seen cases where a self-represented person fails, where having gotten a lawyer, I think they would have succeeded.
Well, on that note, I hope that those watching can help us all as a community do what we can so that children have positive and healthy and loving relationships with their grandparents, because that bond is a very important one. From all of us here at Family Matters, thank you for joining us. See you next time.